payment. Deliver with a detailed breakup, if any, and furnish the same to the finance department immediately, is what they say.
Now let's look at the next paragraph. It is however further directed that required fund is not available under concerned head to the treasury, as the case may be, will arrange for disbursement in anticipation of allotment. So even if there is some discrepancy, they will release the funds.
So we take this on the record.
There's just one, if you watch it, just see page 6 of my note, Malad. This page 6 of my note. So far as West Bengal is concerned, one more item was pending. Para 22, page 6 of my note. By affidavit dated 19/8/24, the state of West Bengal, it is stated that allowances have been revised except for higher education qualification allowance, which is pending hearing in IA number 103071 of 23 months. This this IA months we couldn't look at, it's not there in the case status also. And in any way, there's no question of non-compliance so far as one allowance is concerned. So that also your lordship will actually clarify that para 41 of your lordship judgment of 4/1/24. 4th January 24 will have to be complied. 41.
Medical
41 to 43 minutes. So far as higher education allowance is concerned. This IA we were not able to track at all.
Mr. Dwivedi, that's a.
That will be released also.
We have heard Mr. State of West Bengal, not in every state separately. ऊपर वो state का नाम क्या रखते हैं? State of West Bengal. Mr. Rakesh Dwivedi, then senior counsel appearing on behalf of the state of West Bengal, tendered copy of the memorandum dated 26 August 2024, issued by the Finance Audit Department in the following terms. Copy kar lijiye, and just scan it and copy it. In view of the above memorandum, and the compliance which has been effected by the state of West Bengal, no further proceedings unless
The bills, DDO will have to raise the bills, the drawing and disbursing officer.
drawing and disbursing officer shall raise the bills within a period of
And they will, yes, and they will disburse immediately.
4 weeks. And the disbursement shall be made within a period of 4 weeks of the bills being raised. Next.
But the chief secretary and the officers are here, they may be exempted.
Yes.
And
Which your lordship's kindly.
I apologize for the delay.
So the problem is there are so many states have complied. The problem is when matters are called out repeatedly, the council are absent here. We don't know what to do then, that's the reason why we had to.
Chief secretary here will note your lordship.
We also have no great pleasure in calling the chief secretaries and finance secretaries here,
I
but
understand this.
consistently we call out matters, now they have briefed Mr. Dwivedi when.
Lord, given the state.
Your lordship that.
All right, just 1 second. Mr. Rakesh Dwivedi has also assured the court that the payment of the higher education, the higher qualification allowance will also be duly effected in view of the directions contained, shall be effected, full stop. The directions issued by this court in its order dated 4/1/2024, in brackets paragraphs 41 to 43, are expressly clear.
Yes, sir.
The above payments against the above allowance shall also be disbursed.
The presence of the officers may be exempted.
My lord, as far as the state of.
Proceedings against the state of West Bengal, so far as this aspect need not be pursued any further.
My lord,
Just follow the matter.
Just 1 second.
my lord, in
Lord,
respect of.
Now what we'll do is
Odisha.
page.
3 Odisha.
All right, who's appearing for Odisha?
My lord, I'm appearing.
Yes, the reason why they were not compliant.
States.
1 second. Now let's see.
Of Tamil Nadu, are we, presence of the officer is dispensed?
Dispense with, we have closed the proceedings.
With regard to Tamil Nadu, my lord, there is one difficulty, my lord. The transportation charges are given only with the cars owned in the legal officers. There is some difficulty. The commission says the car owned in the name of the judge as well as of the spouse. But the order says only in the name of the judges. There is some difficulty with regard to that.
Because so far as these individual grievances, there are about 100 grievances that have come up. In the last 2 weeks, I have received emails from different associations of judicial officers. The purpose of constituting a committee by your lordship's order dated 4/1/24 was for exactly this purpose.
So that we are now not required to look at the nitty-gritty of each individual.
That's right, Mulaz. So that if there are minor problems, it is sorted at that level, Mulaz. That's number one. Number two, I should also point out to your lordships, unfortunately, in certain high courts, the committees have not sat for the last 3-4 months. So at the end of today's orders, your lordships.
Just remind us so that we pass that order to
That they must sit once.
the committees in the High Court should sit at least once every fortnight.
That's
What were you going to suggest?
once a month.
Once a month,
at
already,
least
once a
once a
month.
month, because it is,
Become that thing.
because it is a. So then the problems will just take care, otherwise these.
All right, just remind us before we rise, the matter is over today. Now, Odisha.
Odisha is concerned, if your lordship just kindly sees page 8, my lords, what they had done was they had implemented your lordship's order.
Page?
What, page 3, para 8, my lords.
Yes.
They had filed an affidavit stating that all the areas, etc., have been sanctioned. But if you just, the highlighted portion which is underlined, my lords, judicial officers from the state of Odisha also brought to the notice of the amicus that an office memorandum dated 29/2/2024 had been issued, mandating that actual disbursement of areas shall be made over a period of 3 succeeding years. This was further clarified in May, my lords. A subsequent office memorandum dated 16/5/24 mandated that drawal of funds for areas of allowances in 3 phases from 2024 to 2027. So this is why I had categorized them as a defaulting state, my lords, because your lordships had directed that all areas should have been cleared by at least July 2024. So this now stands withdrawn according to an affidavit they have now filed on Saturday. That your lordships will get at page 4, para 10. So far as Odisha is concerned, since this was the concern that all areas were to be distributed over a period of 3 financial years, my lords.
That is withdrawn. So we can close it now.
Lordships, just record this and then close it so that.
Yes. State of Odisha. An office memorandum was issued on 29 February 2024, mandating that the actual disbursement of arrears would be made over a period of 3 succeeding financial years, commencing from 1 April 2024. It's up by a subsequent poem dated 16 May 2024. It was mandated that the drawal of funds for arrears of allowance in 3 phases, it was mandated that the drawal of funds for arrears of allowance would be allowed in 3 phases from 2024 to 2027, into brackets 33%, 33%, and 34% respectively. However, an additional affidavit has been filed on behalf of the state of Odisha on 23 August 2024, indicating that the previous poems dated 29 February 2024 and 16 May 2024, which mandated only partial withdrawal of arrears in phases over 3 years, now stands withdrawn. The additional affidavit has indicated that 44 bills remain pending for processing in respect of arrears of pay, pension, and allowance. This process shall be completed. The above bills shall be processed and payments shall be made no later than within 4 weeks from the date.
May I just state that? Look, these 44 bills have come only after the first affidavit was filed. There's an instruction by the state government to the treasury to make the payment because all the amount was with the treasury, the entire amount. So there's an instruction to pay within 3 days.
All right.
So that's
Then last sentence you strike out, then say, then it's senior counsel, then counsel appearing on behalf of the state of Odisha states that instructions have been already issued to the treasury of the state government to ensure that payment is made within a period of 3 days. The assurance is recorded. In this view of the matter, the proceedings against the state of Odisha on this aspect should stand closed.
Look, the chief secretary and the finance secretary are here in the court.
Do this on time and tell us when the matter is called out that this is done. Yes.
Very great.
Tamil Nadu is done, my lords. Page 4, Tamil Nadu is done. Page 5, Bihar was concerned, my lords. Your lordships had recorded the oral submission made by the council on 11/7, para 18. The council appearing to the state of Bihar. I'm just quoting from the relevant portion of the order dated 11/7. The council appearing to the state of Bihar states that an amount of rupees 122 crores has been transferred to the Law and Justice Department and the payments are being made in full compliance of the orders of this court. What we did, we circulated a questionnaire to all states so that they can upload the relevant documents and also answer on the questionnaire. Bihar did not respond to that, no affidavit also filed. Now they have filed pursuant to your lordship's last week's order summoning the chief secretary's minutes. They have now filed an affidavit stating that they are in full compliance. The reason why Bihar was earlier classified as a non-compliant state was they neither responded to the questionnaire. We circulated an online questionnaire so that specific answers could be obtained.
Who's appearing for this?
My lord, I am appearing for the state of Bihar. My lord, the compliance has been made, it's only because the affidavit was not filed.
State of Bihar, Bihar on 11 July 2024, the following statement of the council for the state was recorded. To invert from us, ये Parmeshwar ji can note में para 18 में copy कर लीजिए quoted portion. Pursuant to the above order, a questionnaire was circulated by the amicus curiae seeking an update on all aspects. Stop. Since the state of Bihar did not either file a response to the questionnaire, nor did it file any affidavit until 24 August 2024, it was classified as a defaulting state. However, on 24 August 2024, the state has filed an affidavit indicating that it has fully complied with the orders of this court with respect to division of pay, pension, and allowances. But the allowances were revised by a resolution dated 28 February 2024. Stop. It has been stated that all the claims made in respect of the arrears of allowances have been disposed of. In view of the above compliance, the proceedings against the state of Bihar, insofar as the above aspect is concerned, shall stand closed.
Personal appearance may be discussed.
Personal appearance is Har ek mein personal appearance is dispensed.
Page 6.
Now we've got
Page 6. West
I'll
Bengal is
just
done.
keep on ticking now. Now we are dealing with
Kerala. But so far as Kerala also is concerned, the same Odisha technique was employed, saying that we have cleared all bills, but there will be a lock-in period. Well, Lordship will kindly see para 24. In respect of payment of arrears of allowances as per geo dated so-and-so of 4th March 2024, arrears of allowances were to be credited subject to the condition that the amount could be withdrawn only after a lock-in period of 2 financial years. Further, arrears were to be disbursed in 3 installments of 6 months each over a period of 2 financial years. Now on 20th, my lords, they have now withdrawn this after we pointed it out to them that this lock-in period was not lordship's orders. They have now withdrawn this lock-in period. But what has happened, my lords, is that pursuant to the March 24 order, they transferred all these amounts wherever they were cleared to a number of judicial officers to their PF account. And that PF was to be touched only at the time of retirement. So that transfer has already happened so far as compliance with the 4th March 24 orders was happened. So your lordship will have to direct that wherever those transfers have happened to the PF account, we'll have to go back to the salary account. So after all arrears, how can arrears be deferred, Malos? And that too for allowances. So medical allowance, DA, etc. They credited it, but they said we'll credit it to the PF account so that you can't utilize it until you retire. The entire purpose of giving allowances and arrears is defeated.
Lordship, with permission, I am appearing for the serving officers, Your Lordship. Lot of other anomalies also there, Your Lordship. I will file a response for that. I am appearing.
I'm appearing for the state, my lord. We accept the position, my lord. We are in the process, my lord, of transferring it from the PF account to, my lord, the salary account. Yes.
Lordship, not only that, Lordship, lot of other problems also there. Let me, I am appealing for the serving officers.
We are arguing before the Supreme Court. We are not going to deal with individual grievances like this. Therefore, we have to institutionalize the process. We have constituted committees in the high courts specifically to deal with this. We are dealing now with national issues where there was an overall non-compliance. Individual issues placing before the committee, we are going to pass an order. Rest assured, we will not leave you in the lurch.
Please.
You are our judicial officers. We will not leave you in the lurch. We'll pass a general direction for these kind of grievances. Don't worry about it.
Please, Your Lordship, only consider the grievance what we are pointing out. That's only, Your Lordship.
Court will be more interested in
Don't worry, we'll deal with it.
So far as the
Your lordship may pass the usual order as far as the persons are concerned. But they are here. The chief secretary.
Yes, yes.
there's the same order.
Kerala. By geo, just 1 second, ma'am. By geo number 66/2024, home dated 4 March 2024. Kerala has directed that arrears of allowance would be credited subject to the condition that the amount could be withdrawn only after a lock-in period of 2 financial years. Moreover, the arrears were to be disbursed in 3 installments of 6 months each, spread over a period of 2 financial years. However, a subsequent GO dated 20 August 2024 has rectified the anomalies which were pointed out by the Registrar General of the High Court in respect of the various allowances. The GO withdraws the lock-in condition and the condition for disbursal of arrears in 3 installments. Mr. K. Parmeshwar, the amicus curiae, further has pointed out that that where the amounts were credited, the credit was made to the PF accounts of the individual officers, which would effectively mean that the availment of the arrears would stand deferred until the date of retirement. Mr. Jaideep Gupta, then its senior counsel, appearing on behalf of the state of Kerala, has stated in response to the above submission that the state of Kerala has already taken steps to reverse the position so that the amounts which were credited to the PF accounts would be retransferred to the salary accounts of the judicial officers. The GO also states that the GO dated 20 August 2024 states that disbursement of arrears would be made as and when bills are presented. Following the the bills shall be presented within a period of 4 weeks. The disbursement shall be made on or before within a period of 4 weeks from the date of the presentation of the respective bills. The proceedings in respect of the state of Kerala shall accordingly stand closed and personal presence is dispensed with. So we are done with now Kerala, which is the next state.
UT of Jammu and Kashmir, so far they are concerned, there is no revision that has happened of allowances, not just payment. Revision of allowances has not happened. Therefore, consequently, payment of arrears also has not happened. So their response,
serious problem.
So they say that the union government has to sanction the revision and the arrears are concerned. The union government had filed a review petition before your lordship, which your lordships have now dismissed on 31st July 2024, so far as all union territories are concerned. So there's no question of now relooking.
We just hold back Jammu and Kashmir and Ladakh for a moment. Now, what about Delhi? What about Delhi?
Yes, goes for UT of J&K and Delhi. That was the problem. Now, since the review is dismissed, I will go ahead with this. We may request.
So far as Jammu, Kashmir, Ladakh, Delhi, all of it await union permissions. So all of them await union permissions.
Union concurrence was required. Now, since review is dismissed, we have.
The Jammu and Kashmir, Ladakh and Delhi.
Actually written to the registrar saying approach this honorable court for clarification. The issue is this, your lordship. Your lordship direction says that 3 advance increments should be given once they acquire a higher qualification and +1 if they get a doctorate. According to us, we've already given that. Now what the officers are saying is that every promotion they should be given that 3 increment again. This is a controversy, your lordship, and this is a genuine obstacle that the state is facing because we have already given.
We have already given it.
Yes, your lordship.
They are now saying that for every
promotion they need to be given.
The normal increment, madam, not the additional increment, normal increment. They say that once you are given 3 increments on attaining the higher educational qualification.
Granted the first ACP, and at the first ACP, all their colleagues are entitled to 1,000 rupees. I'm just giving an illustration. The advance increment is 100 rupees for higher education qualification. So they get 1,100 instead of 1,000. Now the next ACP, my lords, they are all placed at 1,500. So the officers who are claiming this higher education allowance now say that our edge is lost because all of us in the next ACP have been put at the same bracket of 1,500. So we should get it 1,600 also at that point of time because we have actually worked and earned an LLM and a PhD degree so that we are entitled to the advance higher education qualification advance. So ACP is almost like a matter of, because they are otherwise not promotional opportunities, almost as a matter of course. So they say this edge is lost. Every 5 years we are granted the ACP because then all of us become par at the next.
It's a one-time payment.
Yeah, that's the opinion of the finance department.
No, the judgment is very clear. Judgment says that advance increment.
One minute. Your lordship, just kindly just see the judgment para 41 to 41.
That may also be gone into by the committee then.
No, in this case, she's right when she says that the committee has gone into it, they were not able to resolve it, therefore they've filed.
Let's see what paragraphs 41 to 43 say.
Yes.
41.
This matter gets resolved.
Para 41 on this is there. Plus. The SNJPC noted that for acquiring higher qualifications in law, specialized study of the subjects concerned is involved, and the acquisition of such qualification, the nature of a postgraduate or doctoral degree, will improve the quality of work of a judicial officer. The recommendation of the SNJPC are summarized below. The para 42. The recommendations made by the SNJP is that the benefit of advance increment shall not be extended at the ACP stage appears to be covered by this order of this court dated so and so, so and so. There is no justification for denying the benefit of advance increments at the ACP stage. The object and purpose of ACP is to prevent stagnation. On the other hand, the object and purpose of advance increments for requiring higher qualifications to improve judicial performance. Hence, the restrictive condition imposed by the SNJPC in regard to the non-extension of advance increments at the ACP stage is not accepted. The advance increments for requiring higher qualifications shall also be made available to officers who have acquired the degrees through distance education.
So we said even at the ACP stage.
Yes.
For the clarification now, they get first ACP, they get it. Second ACP level at 1,500. So at that time also they must maintain their edge.
Different states are interpreting it differently. So, my lord, I suggest we will just collate it and give it, because this is not a problem only related to this state. Different states are doing it in a different fashion. So this is a problem across the board.
Promotion also it has been.
As regards the grant of advance increments for acquiring a higher qualification, Lieutenant Counsel appearing on behalf of the state of Nagaland states that the directions contained in the judgment of this court dated 5 January 2024 have been duly complied with. However, the issue as to whether the advance increments should be granted at every
stage of the ACP.
Every ACP stage was placed before the committee of judges of the High Court but could not be resolved. Hence, an application for clarification has been filed before this court. Full stop. Both the learned amicus curiae and Mr. Gaurav Banerjee, appearing for the judicial services, both the amicus curiae, Mr. K. Parmeshwar and
BK Sharma, I'm appearing for the
on
judicial
behalf of the judicial service associations, state that this is an issue which concerns other states as well. Full stop. They have agreed to, they have stated that they would prepare a compilation of the position as of the manner in which implementation has taken place of the directions contained in paragraph 43 of the judgment dated 5 January 2024, so that comprehensive directions pan-India can be issued. Full stop. The issue in regard to the payment of the advance increments for higher education allowance as regards the state of Nagaland is therefore deferred and would be dealt with on a pan-India basis subsequently.
Oblige, Your Lordship.
Alert, may I just clarify?
Right. So now,
Apart from ACP for post-graduation also, for a promotion also it has been stopped.
Will be covered by
The same
be
ACP. has
covered by the same
Will be
order.
covered by this order.
Your Lordship,
But Miss, we are prima facie of the view that this must be granted at every ACP stage also. It was not like a one-time
Yes.
one-time incentive.
But now for promotion also it has been stopped for Nagaland state.
We'll see. Promotion you have stopped.
Stopped it.
Your Lordship, yes, we've just
Then we'll
given
resolve.
one time and
Doesn't
that
matter
is
to
up.
resolve it in a short order. It's not a very major thing.
Oblige, Your Lordship.
Now what
Your
is
Lordship,
left is only
the
Now
Chief
what-
Secretary and the Finance Commissioner are also
Yes,
present.
Expensive, yes.
Oblige.
Because Meghalaya is done, Himachal is done, but what is left is Haryana. Haryana, only one aspect, that's para 60 at page 14. The state of Haryana in its affidavit dated 20th August 24 had stated that it has issued necessary GOs revising pay, pension and allowances. The affidavit stated the following. Further stated that domestic help allowance, medical allowance, Your Lordship will kindly note that, are not extended by the state government to any new pension scheme retirees. So what they did, so far as all the other concerns are, conditions are concerned, they have met, pay, pension, arrears, all that has been met. But these two allowances, they are saying if judges start retiring under the new pension scheme, they will neither be entitled to medical allowance nor will be entitled to domestic help.
Mr. Perrin, you have to grant this. What is this?
Minutes, as far as this part is concerned, Minutes, my instructions are Minutes, because this issue specifically, Minutes, this is pending consideration because Minutes, old pension scheme, whether.
But this is independent.
Minutes, we are already giving it to all the serving judicial officers. We are giving it to the retirees under the old pension scheme. As far as the retirees under the NPS, Minutes, for that thing only, Minutes, there is a little ambiguity, Minutes. With respect to this, Minutes, we are saying that whether they will fall.
No other state has this problem.
We'll keep pending.
My lords may decide this issue one way or the other. This
We'll
whole-
decide it with the.
Yes, my lord may decide this one.
We'll decide this issue with the
quickly.
pension scheme.
Please, madam, please.
The state of Haryana, in its affidavit dated 20 August 2024, has stated that it has issued GOs for revising pay, pension, and allowances. The affidavit, however, indicates as follows: Para 60 में copy कर लो. We take on record the assurance that all other allowances, except for the domestic help allowance and medical allowance, have been paid.
Please, madam.
They've been paid, no?
Yes, madam. Even the old pensions, retirees under old pension scheme, they have also been.
It stated that the retirees under the old pension scheme have been paid the domestic help allowance and medical allowance also.
Please, madam.
Stop. The issue, however, pertains only to retirees under the new pension scheme. Since the issue in regard to the applicability of the new pension scheme is pending before this court, we defer further consideration of this aspect.
In fact, I just wanted to add something in that
Yeah.
regard. The new pension scheme has now acquired certain dimension.
We saw
So
the
that
other day.
You'll not defer it for the time being, so that none of those issues are taken up.
My lord, we,
Very
my
well.
lord may decide this issue of old pension scheme
That's all
in
right.
one way, so that, my lord, this is decided.
Right.
I don't think this tweaking will really help. My lord.
All right. So now that is Haryana. Now
On compliance,
Orissa compliance is over.
all is done.
Now we have to, yes, the appearance is dispensed with. No difficulty. Now,
I just wanted to point out that Petty Commission recommendation came in 1999. 2007 is when 99% compliance was recorded. We are much better in terms of the record. 22, your lordships accepted the first set of recommendations. In 24, we are at least 95% compliant. Petty Commission took 99 to 2007, one after the other, coaxing the states into complying with the recommendations your lordships approved. It took 8 years then. The second NJPC has taken much lesser time.
yes.
2 years time.
Now, what are the general directions that we have to issue? We will say that so the present order has dealt with the issue of compliance with the directions contained in the order dated 4 January 2024 and the previous orders. Full stop. Apart from the above directions, we issue the following general directions: bracket 1. In the event that any individual grievances subsist of judicial officers in any state, this may be brought to the attention of the committees of the judges of the High Court, constituted in pursuance of the order dated 4 January 2024. That's one.
In respect of specific allowances, there are disputes that may go to the committee. There are specific allowances partly implemented, not implemented.
To this one above, the direction in one above would also cover any grievances in respect of specific allowances, which should be resolved at the level of the state, stroke duty concerned by the committee of judges.
But so far as the problems that our judicial officers are facing in terms of withdrawal, etc., your lordships had issued specific directions in para 85 and 86 of the judgment dated 4/1/24. Your lordships will say that the high courts will make that compliant, because your lordships have directed them to have standard operating procedures, put it on the website, say how well they can medical
paragraphs
85 and 86 belows. Those directions, your lordship will just reiterate.
High Court, the committees of judges in the high courts constituted in pursuance of the order dated 4 January 2024 shall in particular ensure that a standard operating procedure as mandated in paragraphs 85 and 86 of the order is duly put into place in any event by 30th September 2020.
You said that your lordships will direct them to meet at least once a month or a fortnight.
The four, in order to resolve all pending issues in regard to the payment pending issues pertaining to the grievances of the officers, any subsisting issues regarding the grievances of the officers in regard to the payment of allowances, we request the committees constituted by the high courts to meet once every month that the grievances are resolved expeditiously. I think we'll say once every month.
My lord, I filed an application seeking your lordship's permission to recommend to the government for increasing the retirement age to 61.
Should we get into that? You can always do that, but it requires us to give you liberty.
Because of the
what will happen is, as far as Telangana is concerned, its retirement age to 61. Of what? 1 minute. The government employees' age was increased from 60 to 61 in Telangana. So the High Court sat with the government, and the government put an application before your lordships and saying that the judicial officer
in
Telangana. But that was with the concurrence of the government. The High Court, the judicial officers, and the government was at dialogue, because and your lordship also agreed to it immediately. Those
I remember that order.
Although this commission had said that it's not going to recommend any increase in the retirement age,
That was because the government was willing to do it.
Now there seems to be some concern for the state government.
My lords, may I just take a minute to point out for this?
They have also increased it for their employees from 60 to 61.
In Andhra.
Question is whether that increase also must, the benefit of the increase must also be given to judicial officers. There are two reasons why it ideally should be. One, at the district judge cadre, we are now facing an extreme crunch. We don't get enough officers every year for recruitment across your lordship's knows that. Two, all the special courts that the different statutes mandate are all district judges. POCSO, CBI, politicians' courts, MPs, MLAs' courts are all manned by district judges. So it is something that will actually benefit the system if we increase the retirement age by a year.
There's no reason why the High Court should not take it up with the state.
So the High Court agrees with it. The question is whether the state will now agree with it. Your lordship.
My lords, we have no problem.
The state requested us to send a recommendation.
My lords, if I may explain what has happened. The state had carried out an amendment and increased from 60 to 62. That was set aside by the Honorable High Court in light of my lord's judgment. My lords, therefore, now, as of now, the age is 60. If my lord, for the retirement of judicial officers. My lords, if my lords consider the application of the High Court may approach us and we will consider it in due course. My lords, it is a policy decision and a legislative amendment which must be carried out.
The High Court
You are appearing for the High Court?
Yes.
But why did we set aside the decision of the government to increase it from 60 to
60 to 62?
That's for the civil service, not for the judicial office.
No, my lords, no. For judicial officers, it was increased from 60 to 62. Vijay, an order dated 16/9/22. The Honorable High Court, relying on my lord's judgment in the 4th All India Judges case, says 62 due to hierarchy of courts. The retirement of a district judge at 62 is not permissible. Whereupon Telangana carried out an amendment, made it 61. High Court approached pursuant to the amendment. In Andhra, there is no 61 amendment, which is why
now, therefore, there's really nothing. Okay.
Pending there.
The High Court can certainly approach the government of Andhra to increase it from 60
The
to
state
61.
government asked the High Court to send a recommendation for amendment.
Right.
Now, because of the judgment of your lordships, my lord, the High Court thought it fit to seek permission of your lordship.
We quashed the increase from 60 to 62, right?
Yes, ma'am.
Does that, our judgment prevent the government and the High Court from, increasing it from 60 to 61?
No, my lords, in the state of Telangana, that amendment has been upheld by my lords. In state of Andhra, that amendment has yet to be done. We are only asking that the matter may take its due course in amendment. We may be permitted to consider it, my lords.
Lordship,
Why do you require us to give you a stamp of approval? Let the High Court do it, the Chief Justice is to do it.
Your lordship only say that the High Court may send.
Why should we, something that the Chief Justice themselves have to do? Why do you have to be so?
Because the judgment of your lordships, my lords, in the All India Judges Association says
Look,
that.
that said that 62,
From 60 to 62.
from 60 to 62,
My
because
lord.
there has to be some difference to be maintained.
My lord,
Now, 60 to 61 has
Telangana.
been affected in the case of Telangana. That has the imprimatur not only of the states and the high courts, but our imprimatur also. Now, if similarly for Andhra, if you want to submit a proposal to the state of Andhra Pradesh, please do it. Please tell Justice Thakur to send it across to the state government. We have no difficulty. But you don't require, I don't see why we have to certify that you can do it. Do it. Who's going to oppose it? It can be the state government. It can be the judicial officers. So long as it is something short of 62, why should we stand in the way? Especially because the Telangana judicial officers have got it. Right?
Confusion arose because of your lordship saying.
That's all right. Now there's no confusion. Have a word with the learned Chief Justice. All right? You can show him the order which was passed for Telangana. Ma'am, why don't you do this? Just share the order which was passed for Telangana with the learned Registrar General.
We will do it, my lords. However, they are aware of it. And they are aware that it's
knows
supposed
it.
to
You don't
legislative.
require us to. All right, so this part is over now.
Because only this part is over, Millet. Today also your lordship had listed the suo moto so far as the High Court judges' salaries and the fixation of High Court, a number of issues. So I have just put in a note, Millet, some of those.
Do we take it up today or do we take it up?
Lordship will just adjourn these matters because pleadings are not complete. If
All.
just kindly takes the note for a minute, Millet. There is a horizon. I've just made it easier and put one vertical and one horizontal.
Yes.
Well, this is an entire batch of matters connected with the suo moto. On the last occasion, your lordship had issued notice in the suo moto. There are 3 matters in which I have indicated notice as formal notice has not gone, pleadings are not complete. Your lordships will direct.
Which are those?
Item number 5. 7.
And
15.
5 is refixation. 7 is Singh, right?
Right.
That's Singh Yadav.
That's right.
And 15 is refixation of pension, additional pension.
Right.
So we'll issue notice. They are on board today, right?
They're all on board today.
We'll issue notice. Returnable on Kato. After 2 weeks?
4 weeks. Let the
4
pleadings
weeks,
also be complete. Let the pleadings also be completed, then we'll.
Pleadings be completed in the meantime.
Look, this can be detagged from the All India judges because this is High Court pension.
Detag this. These are High Court pension matters. All right. And detag it and we list it separately.
There are 2 employees matters which have also come in the list today. That also will be detagged and your lordship can call it.
Can you just give him the.
We'll give the numbers. We'll give the numbers.
Employees matters detag kar do, wo alag list hai.
1.8 actually.
We'll take it up.
For a very long time.
Yeah, we'll take it up.
Yes.
All right.
Grateful.
Your lordship.
There is 1.17.
That is in this one. The High Court judges fix it.
1.2.
Your lordship.
This is also the High Court judges in the same batch. High Court, Mr. Dwivedi is appearing in this.
1.17, no, it's a pension matter. I'm not just claiming the benefit of the judgment of your lordship already delivered
Again,
Rahul Garg's case.
High Court judges, my lord. Because there are 3 or 4.
Has been issued in that matter?
Yes, yes, notice was issued.
The union is contesting. There are 3 or 4 sets of matters in the High Court judges case. One, additional judges who were not made permanent, died in office, family is not getting pension, number 1. Additional judges, if they don't complete the requisite qualification as of qualifying years of service as a High Court judge, whether they are entitled to pension at all, issue number 2. District judges who are under the new scheme, new pension scheme going as High Court judges, which is the lead matter your lordship took suo moto cognizance of. because he was not entitled, the gentleman there was not entitled to pension as a district judge because he was under the new scheme. And he became a High Court judge. Even after retirement as a High Court judge, they are giving him the same new pension scheme pension and not the pension that otherwise High Court judges are entitled to. So there are 6 or 7 issues. I have tabulated them, in each one. What is the issue? Your lordships will have it because the union is contesting each one of them.
No. In my case, it's squarely covered by the judgment. There's no question of contest in this case. It's on all four.
I know, but we'll have to hear the other side, right?
The union.
Who's appearing for the union?
My lord, may I need 30 seconds, my lord? My lord, may allow me 30 seconds, my lord.
Your
My
lordship
lord, may
have
allow me 30 seconds, my lord.
lordships have interpreted part 3. We are claiming this benefit as interpreted by lordships. The other thing your lordship
Can we
said.
detag that matter and then hear that? Then just detag that and keep it on another day, on a Friday. We'll see then, so we doesn't get lost in this big bunch.
Only 4 paragraphs the lordship judgment have to pay.
We'll keep it either on next Monday or something.
May I seek my lordship permission, my lord? To mention item number 1.2 to 1.6, my lord. In one of them, lord, the petition of R.P. Mishra, my lord, who is not getting salary for the last 9 months. He's a sitting judge of Patna High Court, my lord.
Right. We are keeping all of them together. And we'll keep it, because there are some matters where notice was not issued. We'll hear it together in 4 weeks and resolve it.
My lord, what is happening is he's not getting salary for the last 10 months, my lord.
Same problem, salaries.
He's a sitting judge of the Patna High Court, my
What
lord.
the concern is this, they are saying he does not have a GPF account, therefore he is not entitled to salary. It's a very weird case, Mullah. They are saying these are officers who are under the new pension scheme. They are working as
Besides that new pension scheme, straight away all this will be over, my lord.
because they are saying because these are sitting judges, judicial officers who were born into the new pension scheme. They don't have a GPF account, therefore we will not transfer salaries also. This is a sitting judge of the Patna High.
My lord, what?
Once your lordship decides that matter, all this will
I am seeking.
fall through, my lord.
Your lord.
Who's appearing for
I
the
am
union?
appearing.
We'll take it up separately in another, we'll keep it up, dealing this matter, just Mishra's matter, and we'll take it up either on Friday or Monday, we'll take it up.
It will take only 1 minute, my lord. If you lordship take, my lord. Only my lordship may see page number 63 and 64.
Who are you appearing for?
For R.P. Mishra, my lord. Justice R.P. Mishra.
We are taking it up. We'll take it up. We are not keeping it in the group. We'll take it up next Monday for Justice R.B. Mishra's matter. And who is appearing for the Union of India?
My lords, I'm here. Learned Attorney General was leading us, my lords.
Right. We ask him to be here next Monday. We'll take it up.
There are judges, I'll give the numbers of all 3 judges, who are sitting judges who are not being denied salary because of this issue.
Your lordship, one more I.
Not receiving salary?
My lord, I need 30 seconds, my lord.
Vested is not of
My
pension.
lord, may allow 30 seconds.
Because you were born into a cadre which did not have a assured old pension scheme. You don't have a GPF account. Our software does not provide for giving salaries to a person who does. That is what I am saying. This is
It's for Friday. We'll take it up this Friday.
very well.
Your lordship.
Take it up
One more.
because tomorrow, Wednesday, Thursday, we are in a CB. So we'll take it up on Friday.
Your lordship's one more application. I am not getting pension since 2014. Notice has been issued. That also may be tagged along with this.
No, that's the district. That's all India judges.
That's an all India judges. These High Court judges, we'll take it up on Friday. Let's at least start clearing. Otherwise, if everybody asks for tagging, nothing gets disposed of. At least let's deal with these 2 matters, Mr. Dwivedi's matter and this matter. We'll deal with it this Friday, and then we'll see how best to move forward.
My lord, we're fixing some date for
timetable. We can look at it then.
deeply obliged.
My lords,
May I circulate a 3-page note? my lord?
Yes, please. That will be on that day. You can give it to us.
in that case, my lordship may direct, my lord. That item number 1.3, 1.2, 1.3 and 1.5, my lordship may be taken on Friday, my lord, because all pertains to the judges of the Patna, sitting judges of the Patna High Court and Allahabad High Court.
All right.
1.2, 1.3 and 1.5. I'm grateful.
1.19 to 1.19.
What is that?
I'm appealing in 1.20.
What is that?
That is also retired judges.
Parmeshwar, what are those matters?
Those matters are, there is a.
From Madhya Pradesh.
Fixation of pension for those judges who came from the district judiciary into the High Court. Their pension is now fixed lower than the judges who are elevated from the bar. Who are elevated from the bar because the same concern, this old pension, new pension scheme. So at some point of time, because your lordship will decide that old pension, new pension scheme, then all this will fall into place. Essentially, my lords, in all these petitions, the argument is for one rank, one pension. Whether you have served as a High Court judge doesn't matter from what rank you
become
came.
a High Court judge, you get the same.
You are entitled to the same pension as any of your colleagues are concerned. That essentially, if you're, that's a short point. If that point is decided, let's
that up also immediately.
That is item number 1.15 also, my lord. The same, my lord, the district judicial.
I will give the list, Millers. I'll give
just
the
give the list. Parmeshwar will give it. But make sure you keep Mr. Dwivedi's matter and RB Mishra's matter first and second. We'll at least take it up, then open the others.
That's 1.15. I'm appearing for the CAG. There's a gap. There's a gap between the service before got promoted. Please,
there can't be a difference in pensions of two people born on the same cadre. Can't be that some High Court judges get one pension, other High Court judges get another pension.
Already covered by my lord's judgment on the redressal.
I'm going to start number 3. No? You just take up.
My lord, I'm praying for 30 seconds, my lord. My lord, in the Kerala, my lord, the state has issued a notification. Whatever you were getting on 31st December 2015, that would be multiplied by 2.81, my lord. This is not correct, my lord, because that payment has to be revised. They have not done it, my lord.
Committee.
This is one thing, my lord.
It's for the allowances.
No, pay.
Pension, my lord.
Why, have you taken it to the committee of judges?
Your order.
My lord.
Because, otherwise 32 will become what? Look at, we have spent 2 hours in the morning only doing this on a Monday. That's why we've institutionalized it. Leave something for the committee of judges in the High Courts. They are right there. They should be taking this up.
We have given that representation, my lord. Thereafter, we have filed a contempt petition, my lord. My lord has directed the chief secretary to come, my lord. That has been disposed of. But this is the fact, my lord. This is for the Kerala, my lord. And then, my lord, Jammu and Kashmir, my lord. Jammu and Kashmir has revised 1996, my lord.
Why don't you go to the committee of the High Court and have them look at it? That's why we institutionalize the process. Everything for every individual state, we start dealing with these individual grievances. It's impossible for us to. Ordinarily, you have to find a 226 petition. Now, just because there's some petition pending, everybody comes with IAs. We have therefore institutionalized the process by constituting committees of judges in the High Court. Surely, there has to be some faith in those committees. We have said we'll meet at least once a month.
My lord, the committee.
All right, we'll just rise for 5 minutes. We'll take up skill number 3.
Just one, sorry. I'm very sorry. Item 2 has been wrongly tagged with item 1. It has something to do with pay revision of the staff of the High Court, which is at par with the Secretariat.
So 2 has to be delayed.
And it is the admitted matter of 2017.
2 has to be delayed.
2 has to be detagged. It might respect something.
Yes.
Where you like.
I may just make a prayer, my lord.